It's a new little Zoom message. All right. Hi, guys. We are back to doing a lot of things in person at the Board of Realtors, which we're very excited about, but there are still some things that I think work better via Zoom and everything else. So we're really glad to be able to do this today. It gets a lot of people on, get a lot of people out there, plus we can record it. So after this is done, it is being recorded. And so if you've got people who weren't able to get on, or if you want to come back and revisit it or anything, you'll be able to find that from the JBOR site and everything. So just keep that in mind. And we were going to go through, there are a lot of changes coming up to forms. These start tomorrow. If you have dotloop, NCAR has now partnered with dotloop, so they should be a little bit more quick uploading, but nobody really has a timeline for any of that. You do have until August 29th to start using these forms, but I would encourage everybody to start using them as soon as you start seeing them. There are some good changes, and it's always good to be using the correct forms. That being said, once August 29th especially rolls around, if you were to get an offer on an old offer to purchase from 2020, or sometimes we even see them from before, you can, with the permission and the very happiness of NCAR and everybody else backing it up, redo the contract on an actual 2021 offer to purchase. They would appreciate that everybody uses the correct forms. So like I said, you have until August 29th to use them. If for some reason you can't access them right away, but please do start using them right away. The exception to that is the working with real estate agents changes. So we did get those a couple months ago. Those have to be in use by tomorrow. So if you have not started using the new working with real estate agents, you need to start using that by tomorrow for new clients. If you have clients who have already signed the old one, it is absolutely fine. They don't need to sign a new one. But from here on out, any new client that you have or any new person that you have for substantial contact with, please do use the new forms. We are going to go over those today as well. If you haven't seen them for some reason, there is a separate one for buyers and for sellers. And then there is also the old brochure. They have taken the signing page off of it, and they are recommending that when you deliver the working with real estate agent disclosure, that you also send along the brochure. It just gives people a little bit more information. So the way that I'm doing it now is I am having them sign the new disclosure, but then I'm also sending the brochure with initials on it, just to cross those T's and dot those I's and everything. So I'm going to start sharing my screen so everybody can see these things. Please, if somebody will let me know if you can actually see the working with real estate agents disclosure.
We can see it.
Cool. Okay. So this one you can see up here does say for sellers. This is the seller one. Okay. So this is not a contract. Same as always with the working with real estate agents. This is a disclosure only. So what NCAR has said is if your office offers any of these items, seller agency, dual agency, designated dual agency, or unrepresented sellers, if your agency offers these things, check each one of the boxes that your firm offers. It is not saying just because the person signs or checks this box for dual agency right here does not mean that they are locked into accepting dual agency forever. It just means that you are telling them that this is an option while working with you. When they do their listing agreement, or on the other side, when we look at the buyer's sheet, when they do their buyer agency agreement, that is when they will select which option they would like moving forward with you and your firm. Okay, so what this form really is a true disclosure. It is saying, if you work with ABC Realty, we offer agency. we offer dual agency, we offer designated dual agency, and we could possibly work with buyer agents working with an unrepresented seller. So that is not going to be the case. If you're going to list a house, that's not going to be the case down here. Okay. And then we have the signatures. We have your name, license number, and your firm name. So it's the same as before. You know, we're not signing these or anything. This is a true disclosure. It is not a contract, but that is the one thing that it came out. Actually, I think there was an article that maybe Jabor posted the other day saying that this isn't them selecting dual agency right now. It is just saying that that is something that you offer. Does that make sense?
Yes.
So we've got that one. And then the one for buyers looks very, very similar. Same thing, not a contract, but it will say for buyers up here. And it will say, you know, one is form 160 is the one for the sellers. Form 260 is the one for buyers, if you ever go by numbers. But again, your firm offers buyer agency, they offer dual agency, they offer designated dual agency, and unrepresented buyers. So if any of these, as a seller subagent, if any of these are possibilities within your firm, go ahead and check those, have them sign off on it, and then they will select what options they want when they sign their buyer agency agreement. So my suggestion, if you haven't already had a meeting with your firm and your broker in charge, to ask them how your firm would like this filled out, just to make sure, because you may not know if it's a possibility for your firm to do designated dual agency. So go ahead and have that conversation with your brokers in charge. Ask them how, you know, for your firm is the best way to be filling this out, and just go with that. Okay. So that is pretty much it. And then, like I said, we also have this brochure. So like I said, the only change is that they took off the little signing area. You can still use the one with the signing area. You can still give that brochure out. There is no change to the information within it. They just ask that what the people are actually signing is that new disclosure. But it is wonderful. It does give a ton of information. You still should go over all of this information with your people. And like I said, I just usually kind of drag and drop some little initial boxes up here to show that, you know, we handed them the brochure as well. But that's completely up to you and your firm. But that is the other option, is that you do still have this brochure that you can you know, hand out for informational purposes. And like I said, if for some reason you have hard copies of the cute little brochures, do not throw those out. You can still give those away for informational purposes. Okay. So now, hold on, I need to go ahead and get rid of some of this stuff. Okay. So now we have our forms changes. So the forms that have changed the most, and the ones that we are going to go over today, are the offer to purchase and contract, and all of them change. So we're going to go over form 2T, but 800T, the new construction offer to purchase, 12T, the vacant land, all of those did change with very similar changes. We're just going to go over the 2T because it'll go over everything, and then you can just kind of see from there on the on new construction or land or any of that kind of stuff. You'll see that those changes will just roll right over to those other ones as well. We're going to briefly go over the backup addendum because we're seeing a lot of those in use, and there was a pretty good change to that one. And then the listing agreement. Those are the three that you're going to see the most changes in. So like I said, if there are, but all of these forms here, every one of these does have some changes. Some of it is just going to be to the wording. I will say that on a lot of these, some of the changes in wording could possibly be as simple as they went from working with real estate agent brochure to working with real estate agent disclosure, because that is a different term that we're using now. Some of these are very simple changes. We're going to go over the more complex changes. Okay, so every one of these does have changes. If anybody did not get this email or list or whatever, we can send it out to you afterwards and everything. The great thing about this is sometimes when we get these forms changes, we just get the forms changes and they'll highlight what the changes are and they'll tell us, but they don't always explain their rationale behind it. And this little handout, this 9-page handout is fantastic because it actually does go over why they change things and what the changes really mean. So this is a great form. And then within here, you do have these clickable links. Okay, so we're gonna click on those as we go through so you can see the changes. Right now, these are all sample forms that we're going to look at today. These are not the forms that you're going to be using, so do not use these forms. Wait for zipforms.loop, whoever else your provider is for forms to release the actual forms, okay? So let's jump right in. We're going to go ahead and click on the offer to purchase and we'll go through it. But if you read through all of these, it tells you what all of those changes are and everything. So we are going to go through those kind of piece by piece. Okay. So here we see that this is when they started drafting it. What you were looking for down here is going to be, it'll say 2021. So just make sure after July 1st, or definitely when you're getting closer to August 29th and everything, that what you're looking for down here all says 2021. Okay, so no real changes up at the top. The first big change is that there now is in due diligence fee, the option for electronic transfer. And if you are going to use electronic transfer, they want you to specify the payment service. So if your seller is going to be getting due diligence via PayPal, Zelle, Apple Pay, whatever they are, they'll have the options for cash, personal check, official bank check, wire transfer, and electronic transfer. But if you are going to do that due diligence fee by electronic transfer, please do write in how they are going to do that. Okay. The second change is on initial earnest money. What the wording used to say is that the initial earnest money was going to be given with this offer. We all know in reality, especially as we're talking about zip forms and .loop and DocuSign and all of that, that a lot of times you are not handed an offer with a check paper clipped to it anymore. That's just not the way that 99% of business is done anymore. A lot of it is electronic. So you're not necessarily getting that check along with the physical offer. So now what the contracts are saying is that you will deliver the initial earnest money by the effective date of the contract. So if your buyer sends their signed offer to the seller and they're offering earnest money, you do have until the seller signs, everything's fully ratified, all of that, to get them that initial earnest money. So it makes a little bit more sense. Okay. And then we have for additional earnest money, again, they have the electronic transfer added in here. So if you cannot get earnest money to the escrow agent by the effective date, go ahead and use the additional earnest money instead. And then you have this line here, 5 p.m. on what day? What day are you going to be able to get them that money? Oh, sorry, somebody. Okay. So we're going to go through and just kind of read some of these when we've got some big highlighted changes. So if the parties agree that the buyer will pay any fee or deposit described above by electronic to cooperate in effecting such a transfer, including establishing any necessary account and providing any necessary information to buyer, provided, however, buyer shall be responsible for additional costs, if any, associated with such transfer. So if your seller has not, if they don't already have a Zelle account or a PayPal account or anything like that, and that's how they agree to accept the due diligence fee, this is just saying that the seller will go ahead and set up that Zelle account or PayPal or whatever. And they will supply, usually you need a phone number or email address or something like that to the buyer so that the buyer can effect that transfer. But if any of these services do have a fee involved in setting up, and that is what the buyer and seller have agreed upon, to use that particular electronic transfer method, that the buyer is going to pay that fee to get that service set up. Most of the fees that I've mentioned, or most of the services I mentioned already, are free services to set up. So I don't know what that would necessarily be to set up, but just do be aware that if your buyer absolutely needs to use X transfer service and there is a $5 fee to set up X transfer service, the buyer's going to transfer $5 extra, or do say, they're going to make that payment. Okay. So here is one of the big changes. So we're going to keep seeing this. See paragraph 23. Paragraph 23 we'll go over a little bit when we get to the end, because 23 is close to the end of this contract, but you're going to see this, see paragraph 23 pop up a bunch on the offer to purchase. It's really going over how you settle money and due diligence fees, earnest money, and all of that. And basically, it's always been kind of a bone of contention that the sellers, they can keep due diligence fees, to keep earnest money fees, depending on when and how the buyer terminates and everything. But that was it. That was all they were, that was the be all and end all of what they would be able to go after if a contract terminated. And now what the contracts are saying is that the seller can recover the due diligence fee and earnest money deposit paid already or in the future, and we'll get to that. In addition, seller may be entitled to recover reasonable attorney fees or court costs. So this is great because that was never explicitly put out there before. The seller really just had the due diligence fee and the earnest money that they could recoup, and that was it. Now there's a possibility that they can also recover reasonable attorney fees, court costs, and fees incurred in collecting earnest money deposit or due diligence fee. Okay. So the next change in this, basically they changed this whole section on earnest money because the way that it read before was really kind of assuming that a lot of firms held earnest money. And what the Bar Association and NCAR and everybody have determined is that a lot of firms don't hold earnest money anymore. Most of the time it is going to like a closing attorney. And because there was really no guidance on how quickly those attorneys had to deposit things and do all of that, they just wanted to make this a little bit more clear that this earnest money going to any escrow agent, with the understanding that a lot of times that's not going to be a licensed realtor, that it is going to be deposited promptly. So really that's the big change here. And then all of this wording is taken out of this section and put into that paragraph 23. So they're really consolidating a lot of issues into that paragraph 23 so that you can basically read the contract. And then when you get to 23, you can really talk about money dispersal and all of that all in one place, which is great. Okay. So again, escrow agent, and I have to throw this out here because this drives me nuts. If you are writing a contract and you only have due diligence money and you do not have any earnest money, there's not an escrow agent. So please don't write an attorney's name on there if there is only due diligence. If you do want it to be known who your buyers are choosing for an attorney and everything, I will write in there NA closing attorney to be Joe Schmo attorney at law or whatever, but you don't have an escrow agent if there's no escrow money. There is that. Okay. So again, we're back to see paragraph 23 for a party's right to attorney fees incurred in collecting due diligence fee. Okay. And this due diligence fee is going to come in. The reason why we're talking about this is going to come in just a little bit later as well. So special assessments. This has always been kind of a bone of contention for people too. So special assessments, we know that there are agents out there who will write on every offer to purchase, none, if any, to be paid by seller. That is not the greatest way in the world to write or accept something, especially if you represent the seller, because your seller may not know They may not have been approved by the HOA or the city or the county or whoever is going to collect those assessments. So basically what this boils down to now is that any assessments that are in fact before closing, yes, the seller will pay. Anything after closing, the buyer will pay, which is how it's always supposed to have worked anyway. But now the burden of those assessments is placed on the buyer along with our caveat emptor contracts, buyer beware, buyer due diligence. This is part of their due diligence, is finding out about those special assessments. So we did have a lot of discussion on this one when we went over these forms the first time. So there are some issues with this that could potentially come up. If you guys have worked with HOAs a lot, you know that the HOAs don't particularly like to give information to realtors, and they don't necessarily have to give information to buyers. But now we're asking the buyers to come up with all of this information on their own. So there are going to be some hoops to jump through and all of that. When we get to the listing agreement, I'm going to show you the change to the listing agreement that makes this a lot more palatable for buyers. But just know that finding out about these assessments and everything else is now part of your buyer's due diligence, which means that it's something that we're going to have to get a little bit better at in discovering. But it makes sense. Just like, most things in our contracts make sense. If an assessment has been assessed before the house closes, that assessment is going to be attached to the seller's name and their address and title, and all of that stuff should pick up a lot of these things if they have been assessed before. If they haven't been assessed before, the seller doesn't own the house anymore by the time the assessment comes due, probably should be the buyer. It's their house now. So it does make sense. It's just one more thing that we're going to have to take a look at. Okay. So real quick, one of the things I did want to go over when we were talking about that due diligence fee, is so with these new changes, we'll come back to that because we're getting to it in this next section. So this is one of the things that had come up with fixtures and all of that. Specified items with fixtures and personal property, if present on the property at date of offer. That should be relatively apparent to people, but that is something that does need to be said. So if there's not a storage shed that exists on the property on the date of the offer, and then they bring a temporary pod-like type thing, that doesn't mean that it's staying. So it is present on the date of the offer. And unpairing and deleting, we have more and more smart homes and everything. So if the seller would forget to unpair some of their smart home features before closing, that their need to unpair those devices does survive closing. They've made that obvious in here too. Again, with personal property present on the property on date of offer. Okay. Special assessments, investigation of the existence of special assessments that may be under consideration by a governmental authority or an owners association is now part of the buyer's due diligence process. Okay, so this is what we were talking about. They have all of these same things that they've always had to do. They can do inspections, they review their documents, they talk about insurance, appraisals, surveys, zoning, all of that stuff, and special assessments now. Okay, so that's where that comes in. So this is where the due diligence fee and why this came into being, where we're talking about recovering with attorney's fees. Okay, this is a big change. Buyer's right to terminate. Buyer has delivered any agreed upon due diligence fee. So provided that buyer has delivered any agreed upon due diligence fee, buyer shall have the right to terminate this contract for any or no reason by delivering to seller written notice of termination during the due diligence period. Okay, so let that sink in. If the buyer and seller agree that there is going to be due diligence as part of this contract, and the buyer does not timely deliver that due diligence, they don't get to terminate this contract for any or no reason and get that earnest money back. Okay, so if they have done both due diligence and earnest money, and they just are withholding that due diligence until, you know, they run some inspections because they're really not sure, and they're like, oh yeah, I forgot. And then they're like, nope, we're gonna go ahead and terminate, give me my earnest money back, no skin in the game. That's not available to them anymore. If they have not delivered this due diligence fee, they don't get to terminate within the due diligence period for any or no reason, and they will not get that earnest money back. Well, we say will not. We all know that everybody has to agree where the earnest money goes, but this is where it goes to the courts. And this is where the powers that be don't want the seller to always be responsible for all those court costs, because if a buyer purposely withheld due diligence money, thinking that they might terminate, and then they didn't have to pay anything, they didn't have to pay due diligence money, they didn't have to pay earnest money. And now if the seller wants that due diligence money, they're going to have to take them to the magistrate or court or whatever, and the seller wouldn't be able to recover those court costs. You know, what seller is going to keep doing this? So now all of this boils down to is, if your buyer agrees to pay due diligence money, have them pay the due diligence money, because then they actually get their due diligence period. All of the things should be good, but we're seeing more and more examples of people making a kind of a conscious effort not to pay that due diligence fee, or, you know, just, you know, delaying it for so long, and then they really don't have any skin in the game, and that's not fair to the seller who has taken their home off the market during that due diligence period. So in the, you know, expectation of everybody working fairly towards their correct, you know, due diligence, towards closing, towards all of that, just make sure that due diligence fee gets to the sellers. Okay. So this is another big change on the buyer representations. This whole section has changed how it looks. So if they do need, if they're not getting a loan, if they're paying cash, you check the first box. And I love this, that it actually says verification of cash available for settlement is or is not attached. I know, you know, we always ask people for pre-approval letters, pre-qualification letters, all of that kind of stuff. If it's a cash deal, you know, I know most people would be asking for some sort of proof of funds, but I love that it is now going to be on the contract that, you know, that this verification is or is not attached to the offer, because it is important for the seller to know what kind of offer they're accepting. You know, if someone says, yeah, this is a cash offer, so we want to win this multiple offer situation or whatever, and then they never provide a proof of funds, well, then what happens? Okay, and we kind of get down to here too. If that happens, and you know, it can happen. So this is now a material change. So material change with respect to funding on the part purchase, if that's going to affect the terms of the contract, it's a material fact. So how I see this is, if someone they were going to use cash, let's say they had every intention of making this a cash purchase, all of that kind of stuff, but then something happened. Could have just been that they got a great offer on a loan and they just decided not to use their cash, whatever. If they change their mind and change the way that they are going to finance or pay for this property halfway through the loan, whatever, it is now a material fact and it has to come back in. So what does that mean? If you're changing a term of the offer, what does that mean? Is it a renegotiation? If you said that you were a cash offer and now you're not a cash offer and you're financing and now there's appraisal restrictions and all of that kind of stuff, you know, does the seller have a right to, you know, renegotiate the buyer is now renegotiating terms, you know, so there's just things that we're all going to have to talk about. This does happen. And if, you know, somebody won a multiple offer situation, or just, you know, the seller was happy with this because it was a cash offer and now it's not a cash offer anymore, it's not the same offer. So these are things that we will definitely, you know, have to talk about as this becomes, but just do know that that is a material fact. So if you do have the buyer and you know this is coming, you know, it is part of your duty to let that listing agent know ASAP that, you know, this material fact is changing. Okay. The other change to this is how this entire section on loan type and all of that stuff looks. Fair housing and all kinds of issues kind of come into play with some of the questions that were being asked before. You know, some of the things that we had put down in these sections may have biased people against using and all of that. So really, this is just streamlined. What type of loan are they using? That's it. We don't need to know the terms. We don't need to know the points. We don't need to know any of that kind of stuff. We just need to know, are you using FHA, VA, conventional, USDA, some other type? And that's it. And then there is another section for other funds. We all, you know, hard money loans, all that kind of stuff. There are other ways of financing houses. So all of those can now be in here, and it just makes it a lot cleaner and a lot less chance for bias and, you know, potential issues stemming from that. I'll be interested to see if some of these changes change the way that lenders send pre-approval letters and pre-qualification letters, because we all know that every lender pre-approval letter looks a little bit different from the others. I don't know if they'll start redacting more and more information from their letters so that it basically follows this, where you really are just saying this person is using this type of loan, this, but none of the specifics. So I guess we'll find out from our lender partners kind of how that changes as well. Okay, so once again, we're back to buyer obligations and those special assessments. Okay, so these special assessments may be approved following settlement, and those are going to be the responsibility of the buyer. Okay, once again on the assessments and these little lines that everybody loves are going away. So there's no longer going to be those check boxes for, to the best of seller's knowledge, there are not proposed special assessments. And again, when we get to the listing agreement, I will go over it. This is not releasing the sellers from disclosing what they know at all. And that is taken care of within the listing agreement. So we'll get to that in just a little bit. So don't feel with no help from the seller. Okay. And again, payment of special assessments. If they are approved prior to settlement, they are a seller obligation. Okay. So seller obligation, assessments that are approved prior to settlement, they will attach themselves to the seller. They will attach themselves to their name, their current address, title, all that, you know, depending on what kind of governmental entity or HOA or whatever is assessing it, it will attach to the seller if they have been approved prior to settlement. Okay. All right. So once again, seller's failure to comply and their breach, this whole section is wiped out, and it's going to be in paragraph 23, which I promise we are getting to. All right. Prorations or adjustments, they have just made this a little bit more clear that any taxes and dues that the seller is entitled to the amount of prorated rent through the date of settlement. That'll make sense. It's just kind of clearing up some language and everything. So this is one of the biggest changes. Delay in settlement of closing. most of us know and probably put into some sort of spiel when we are talking to our buyers and sellers that, whatever date we throw in the offer to purchase as the settlement date is probably the one day of the year that it is not going to close. I know we all make jokes about that, but this window has existed on a Form 2T for forever. And we had a 14-day window. So we have settlement date on the contract, and then 14 days before that date and 14 days after that date, we didn't need an extension to say that it's going to close within those 2 weeks. Now lenders may have all that kind of stuff, that's completely separate from this offer to purchase, but on a Form 2T, as long as everybody was reasonably working towards a closing date, we had a 14-day window on either side. That is dropping to 7 days. That is real. This is tightening up what kind of issues there can be. This absolutely does not mean that you cannot extend. You can't, you can still use that Form 4T to extend due diligence dates, closing dates, change the price of the house, do all that stuff. So, but just know that if you are going to be outside of a 7-day window now, not a 14-day window, you need to start talking about getting that extension signed, because it does have to be agreed upon by all parties. Okay. And we'll kind of click through that as well. There is verbiage in that Form 4T saying that if you extend the date, it implies that you still have this 7-day window. But there is a box underneath it that you can check under that settlement date that changes that to 4 days instead of 7 days. 4 days to 7 days isn't as big of a deal difference as the 4 days to 14 days was, but do know that if the non-delaying party doesn't want to keep giving that 7-day window, that extension form does have an option to just make it 4 days. And that's usually good enough to move closings around and all of that kind of stuff. Okay, so just do be aware that the other change to this is that what this used to say for the delaying party is that everybody's working with reasonable diligence and all of that, and they just are unable to close on time. What it says now is that it is not possible for the other party to complete settlement. So this changes the theory of the law from being I can't get my movers to show up in time, I can't complete closing. That means you don't want to complete closing. What the contract now says is that it's not possible. So these are going to be lending concerns, attorney concerns, title concerns, all of that kind of stuff. It's really trying to hem people in to, if you are going to delay, and by delay, we mean outside that 7-day window. If you are going to be the delaying party, it has to be because it is impossible to close this on time. Okay, so it's kind of a swing in the way that we think about things, but just do be aware that if you are going to have to delay and you are going to be the delaying party, it really does have to be for a possibility reason, not just a kind of I want to reason. It would be more comfortable for me to close. Now, if it's a comfort thing or if it's a non-possibility, impossibility thing, and everybody agrees to the extension, that's completely different. Again, every term is negotiable on our contracts and all of that kind of stuff. So if both parties agree to go ahead and extend it, it doesn't matter what the reason is. But if you are if the non-delaying party is not agreeing, it has to be a possibility, impossibility reason. Okay. All right, so finally we come to paragraph 23. So this is a new thing. It does go over what happens in the case of breach by buyer, breach by seller, and then attorney's fees. Okay, and then this last little note is also a good one. So we'll go over this. So I'm just pretty much going to kind of read through most of this. Most of this has, for the buyer, not really a whole lot of changes. It's just put all in one place. Okay. So in the event of a material breach of this contract by the buyer, seller shall be entitled to any earnest money deposit. Okay. So if the buyer breaches, seller shall be entitled to any earnest money. Again, we know that we always, everybody has to agree on where the earnest money goes before it goes anywhere or it goes to the magistrate. Okay. So the payment of any earnest money, any due diligence fee to the seller shall serve as liquidated damages. That's the same as it's always been. And as seller's sole and exclusive remedy for such a breach, here's the change. But without limiting seller's right under paragraph 4 for damage to the property, it is acknowledged by the parties the amount of liquidated damages is compensatory and not punitive. Okay. So, and it's a reasonable estimation of the loss. So this last line, the payment to the seller of liquidated damages shall not constitute a penalty or forfeiture, but actual compensation for seller's anticipated losses, both parties acknowledging the difficulty of determining seller's actual damages for such breach. So we're changing the way we're thinking a little bit. The seller can keep due diligence, can be entitled to earnest money, but that they can also be compensated for damage to property and for actual losses. And it is difficult to compute the actual losses, but as long as it's just compensating them for those losses and not punishing punitive, not punishing the buyer for inconvenience or all of that, they do have to be actual charges or a good estimation of those. Breach by seller, in the event of a material breach of this contract by the seller, if the buyer elects to terminate this contract, buyer shall be entitled to return of both earnest money and due diligence fee together with reasonable costs actually occurred by buyer in connection with the buyer's due diligence. So this provision shall not affect any other remedies available to the buyer. That part all kind of stays the same. We did talk a little bit when we were talking about like special assessments and everything. So if you were to purchase a program like HomeWise or whatever, if the buyer were to, in order to get HOA documents and all of that, this can all be recouped if the seller materially breaches. So just, be aware of some of those things as you're talking to your buyers about what they're doing within due diligence. They are protected if the seller materially breaches a contract. They can recoup those due diligence costs as well. Okay, so this is really the new part of paragraph 23. If legal proceedings are brought by buyer or seller against the other to collect earnest money, due diligence, or due diligence costs, the parties agree that the party shall be entitled to recover reasonable attorney's fees to the extent permissible, and that they agree that the terms of the contract with respect to entitlement constitute the evidence of indebtedness. So all that being said is if the buyer breaches and the seller is now entitled to that earnest money and the seller has to take them to court, the contract saying that if A happens, B happens, if that's the evidence of indebtedness, that the seller should be able to recoup that earnest money. So it just kind of puts it all in. Yes, you can argue till you're blue in the face about where that earnest money goes, but the contract says what the contract says, and that's all going to be taken into account by the attorneys. This note is important at the bottom though. So the party that is seeking recovery of attorney fees must give written notice to the other party that they have 5 days from the mailing of the notice to pay the outstanding amount without attorney's fees. So because we're now allowing everybody to be able, both sides to be able to recoup those attorney fees, if your client is going to go after the other side, including those attorney fees, send them a written notice and so that basically they have the option to go ahead and say, okay, well, I don't want to have to pay attorney fees, so I'm going to go ahead and sign over that due diligence or that earnest money or whatever. It just gives everybody one last window before we put the burden on the court system to move forward that, hey, this is about to go to the courts. If you lose, you're paying all the attorney fees. I'm asking you one more time for the earnest money. If you've done that and you've given the 5 days, your notice. So just do be aware that there are kind of, timelines put into play with all of that because of some of these other things that we are trying to recoup. Okay. So just some notes before we move on to some other forms and everything. But if the buyer does not deliver that due diligence fee, that is now considered a breach of contract by the buyer. Okay, so if going all the way back up to the top and everything, they have to deliver if they have agreed upon due diligence fee. If zero is a due diligence fee, this doesn't apply or anything. But if that buyer does not deliver that due diligence fee, that is a breach of contract. Seller can terminate, and they're owed that due diligence money. So again, make sure your buyers, if they agree to due diligence money, are getting that due diligence money to the sellers ASAP. And again, they don't have that the clause of being able to recoup earnest money if they haven't paid that due diligence money, all of that. So all of that kind of plays together. Okay, so those are the big takeaways from the offer to purchase. I'm seeing some. So I can send this to Heather, all the marked up versions and all of that kind of stuff, and she can email it out to everybody who's on this call and everything. That include inspections. Okay, hold on. I got to start from the beginning here. The seller refuses to extend and DD has passed, the buyer cannot close for whatever. Yes, so sorry, reading. If a seller refuses to extend and the DD period is passed, but the buyer cannot close for whatever reason, can the seller retain EMD? Yes, if the buyer can't close and you're outside of that, again, the contract says that the seller should be able to retain that EMD. But again, everybody has to agree on how that is handled. So if they don't agree, it's going to go to the magistrate. But again, if the letter of the contract says that that should be whatever your evidence of indebtedness does say, that probably should revert to the seller. Yeah, so again, compensatory damages and all of that's above our pay grade. We're never going to be able to be the ones that decide who gets paid for what. But again, if it does go to the courts, the contracts are now reading that both sides, do have the ability to be compensated for any damages or losses that they sustained during the contract. So at least everybody has a fighting chance to recoup losses. So yeah, we'll send out that striped up version. Sharon sent those forms. That's that little link if you want to click on that. Okay, so so let's move back to, I always do this wrong. Okay. So real quick on so we also have all of these changes to the vacant land and stuff. Anything that really changed on 2T is also changing on vacant land, construction, all of that kind of stuff. The backup addendum, just because we're seeing more and more backup addendums, the big change is right here. So initial earnest money deposit. Okay, initial earnest money deposit shall be made payable and delivered to the escrow agent, even though it is in the backup position, promptly upon receipt to escrow. And then, so even if you're the backup contract, and if you have offered initial earnest money, that initial earnest money needs to go with this backup offer. You don't wait until you become primary to pay the initial earnest money anymore. So if initial earnest money is part of the backup contract, you need to deliver that initial earnest money to the escrow agent, and it'll be held in escrow until you're either made primary or until your backup contract is wiped out. If the backup contract wipes out or whatever, then you'd give that earnest money back. But just please do be aware that if you offer initial earnest money on a backup addendum, that money is due when with that offer. Okay. So that's the big change on that one. Again, talk to your firms and everybody else about whether it would be better to not do initial earnest. I don't know. That's not mine, but just do know that that is a change. Okay. So there are changes to a lot of little things. The Owners Association addendum, they've taken condos out of there because it never really made sense that condos were part of that. They have their own stuff, all of that. So the other one that we want to go over today is the listing agreement. So again, first change to this one is that it's not called the Working with Real Estate Agents brochure, it's called the disclosure. So again, we're going to have little changes like that for all of those. Again, on the fixtures and personal properties, if present on the date of the offer. Unpairing devices shall survive closing, present on the property on the date of the offer. So all of these changes mirror what we just saw in the offer to purchase. Okay. So here's where we come into the big ones. I've seen a couple people, I know like a lot of times when we're posting on social media, a lot of times you just kind of copy and paste things from Inmon or some other sources or whatever. And a lot of people have been talking about these buyer love letters. NAR, NCAR, regional MLS, nobody really encourages these. And the main reason is that there can be some pretty hefty fair housing violations that go along with this, whether intentional or unintentional. The problem is that you send a buyer love letter and let's say you even include a picture of your family. And you may just be saying, look, we're real people. We want you to consider our offer. And that's lovely. But you don't know how the seller is going to take that. You don't know if the seller may decide that your family is or is not the type of person they would want to sell to. That's not fair, and it's not part of the way that realtors work, and it is not, it's not fair housing. It violates every bit of what we believe in as realtors for that to happen intentionally or unintentionally, because you have no control over how your seller's mind works, and they may be doing it consciously, subconsciously, you don't know. So discuss it with your sellers and your buyers and your firms and your brokers in charge and anybody who you trust to talk about this with. But my policy is to talk to sellers when we're about to list a house and say, if I receive one of these, it's as part of the offer, we are supposed to pass it along to you. I would request respectfully that you do not read it, that you put it in that circular bin over there. Same thing with buyers. If you're working with buyers and they ask about this because this is how their family in XYZ state over here does it, I would really caution them that it's not best practices possibly, and explain to them why. We all know that this is a hugely competitive market and everybody wants to put their best foot forward, but we really do have to be mindful of why we're doing what we're doing. And we don't have iron control over how other people act. And it's just, everybody has found it important enough to disclose this on a listing agreement at this point. So again, talk to your brokers in charge, talk to anybody who you respect, read articles on it and everything. But I would suggest trying to talk people out of buyer love letters, either the writing of or reading of, just because that's what we believe as realtors, is that we want fair housing for all. Okay. So here is a giant change. So we know that we've had a lot of discussion on coming soon, on office exclusive, on delayed marketing, on all of these things. And it's really hard to narrow down exactly what everybody's what their intentions are, what the buyers or what the sellers' intentions are, what the realtors' intentions are, how we do this, what's best in this case. You know, NAR comes out with clear cooperation policy where we have 1 day to get things in the MLS, and you know, all these things kind of seemingly working against each other, trying to figure out how to do this correctly. The changes to this listing agreement should help clear up a lot of unknowns. And regional is going to be meeting within the next day or so to talk about any changes that need to be made to flex to reflect some of this, because there are changes to wording and all of that kind of stuff. So basically, this whole marketing, these whole paragraphs are kind of going away and simplifying a lot. So commencement of marketing. We're going to start marketing on this date. So all of this stuff from you've got 3 days to do this and 1 day to do this and all of that to do this is simplified into, you know, we can all sign this listing agreement. It can be fully ratified on, let's say, July 1st. But the sellers and the firm have agreed in writing on this listing agreement that we are going to commence marketing on this date. Okay, everything else you don't have to worry about. So, you know, I know there's been back and forth on the best way to even sign listing agreements. You know, if you know that you want your sellers to sign this listing agreement so they're locked in with you, and that's all great, but that, you know, your photographer has told you that it's going to be 3 days before you get pictures even back, or let's say 4 or 5 days. And so you as an agent decide, well, I'm just not going to sign it. I'm just going to hold on to the listing agreement and sign it within 3 days of being able to get it in the MLS, because that's the simplest way to do it. There's nothing officially wrong with that. But it does not protect you or your firm. So your broker in charge might not be very happy about that, because what if the seller decides, oh, actually, my best friend from college just told me that she got her license. So you haven't signed yet. So we don't have a listing agreement. Great. I'm gonna go list with my friend. You're not protecting yourself if it's not fully executed. So this takes some of those questions away from that. You can all sign. But you've all agreed in writing in this very specific place that yes, we have a valid listing agreement as of this date when we all sign, but we're not quite ready to market yet. So we have this form right here, commencement of marketing, this date. Okay, so hopefully that will take care of some of those problems. And then firm is obligated to present to seller any offers on the property that may be submitted prior to the delayed marketing date, all of that. So, I mean, all of these things with coming soon and everything still exist. This just clears up a little bit of that option. Okay. Then we move down to the next ones, the marketing authorization. So we just wanted to make a little bit clearer the difference between public marketing and non-public marketing. You know, a lot of people are using office exclusives for various reasons. I'm not here to tell you if it's a good strategy, a bad strategy. It's a strategy as long as it is in the seller's best interest, and that's what you've discussed with them. That's between you and your firm and the seller. It is if it's what's best for them, it's what's best. So, but basically what this boils down to, this whole section is really explaining that there is a difference. So you are choosing public marketing or office exclusive. Those are two very separate things. Okay. So it's going to be advertised, social media, signs, flyers, absolutely anything. If it is going to be marketed publicly in any forum whatsoever, public facing, it is not an office exclusive. It is public marketing, okay? Two very separate things. So if they do agree to public marketing, everything goes to the MLS, and then we go on from there, okay? So if it is public marketing, that includes coming soon. Coming soon can be publicly marketed. You know, go ahead and put those disclosures in there that it's coming soon, that it's not active. Obviously, you can't show it, you can't do all of those things, but it is still publicly marketed. So coming soon is part of public marketing. This makes it very clear. Option 1, public marketing, coming soon, okay? And this is great too. So this takes out another question on when, why, where, Exhibit 8, like all of these other things that we've always had before. This is kind of bringing it all into the listing agreement. So there's not so many questions on did the seller know what the intention was on marketing? Yes, they did, because it's all in our listing agreement, okay? So coming soon means what it means. Any restrictions, requirements, Exhibit 8s, all that kind of stuff, are they or are they not attached to this? And then the status of the listing shall be changed to active on this date. So everybody is aware of, we have the signed listing agreement. We're ready for this to be marketed as a coming soon on this date. We're ready for it to be marketed as active on this date. All on one form, all very easy to read for the sellers, okay? And then same things. Are we doing signs? Are we doing open houses? Are we doing advertising other than the internet? Are we doing advertising? The only thing that's really changed on these boxes is that coming soon used to be down here, and now it's just being brought up top because it's easier to read. It's easier to understand and everything, okay? So we've talked about the date we're gonna have an active listing agreement, the day we are commencing marketing of any kind. Are we doing public marketing? Are we not doing public marketing? Okay. So if we are not doing public marketing, the seller withholds consent for the listing to be publicly marketed, including social media, and disseminated to other participants of any listing service. Okay. Seller understands and acknowledges that the rules of the listing service may require that the listing still be filed with the listing service. That is the case of our multiple listing service, our NC regional, okay? And that the listing service may require the firm to provide certification signed by the seller that the listing will not be disseminated to the listing service, okay? That's Exhibit 5. So if the seller wants to withhold the listing from the MLS, you still have a signed valid listing agreement. You're working on that right here. You're still going to send paperwork that regional requires to regional. And with office exclusives, you still put it in the MLS. You put it in the MLS. You just checked office exclusive. So it's not going to be visible to anybody outside of your firm. Okay. And also when we say firm, we know that there are some big firms out there that have multiple offices all over the place. So if you work for a firm that has a Jacksonville office and a Wilmington office, and you do an office exclusive in your Jacksonville office, only the Jacksonville agents can see that in the MLS. The Wilmington ones cannot. They are not part of that office exclusive. It is an office exclusive, not firm-wide. Okay, so just kind of making that apparent too. So this is another important part. So the firm is prohibited from marketing the property publicly, including any of the methods listed above, if at a later date the property is going to be marketed publicly. This listing agreement must be amended accordingly. And they're suggesting Form 710, which is the agreement to amend agency agreement. So what this means is that your seller can't not know. This information cannot not be disclosed to them. So if they have signed this listing agreement wanting an office exclusive, which means that it doesn't go publicly into the MLS and means that it's not on social media and there's no flyers that the public can see, there's no sign, there's none of that stuff. And then it does get marketed somehow, either purposely or not purposely, that it needs to be disclosed to the seller that this is now not an office exclusive anymore. There's no secret to that. If it's going to go from being office exclusive to any kind of public marketing, including while it's under contract, you need to get an amendment signed that your seller knows that it is coming out of office exclusive and into public marketing. Okay. One of the things that has come up on this too is, this specifically says firm is prohibited from marketing the property publicly. It's NAR policy through clear cooperation and everything that's not just firm. If for some reason you had an office exclusive and the seller decided to market their home publicly, it's now not an office exclusive either. And you'll still need to get that paperwork and all of that kind of stuff. But just make sure if your seller has decided with your help or whatever that office exclusive is the option for them, please just do make sure that they understand all of it, that it's just your office's little secret nugget there, that nobody else is going to get that publicly marketed information from you or from them. Okay, so no, oh, congratulations to us for putting our house on the market, and just make sure that they understand that it can be marketed by anybody and still be publicly and be an office exclusive. Okay. And then this just kind of reiterates the clear cooperation policy. You've got 1 day. If it were to become publicly marketed, you have 1 day to get it into the MLS as active, and you can't do that yourself. So if you were to put a listing in as an office exclusive, and then you wanted it to not be office exclusive anymore, you have to go through the associations and regional and everything for them to click that button to make it active, and you've got 1 day. Okay, so just make sure that if something either goes wrong, an actual oopsie, or if the seller decides that it's just not for them or whatever, that you're getting that amendment. I would recommend sending that amendment to the association level and to regional level or whatever to say, hey, this needs to come out of office exclusive. Here's the amendment saying that the seller, aware of that and everything, and that we're going live. Okay. Still with lock boxes, seller acknowledgements, all of that stuff's the same. So office exclusive, this section has just been moved up to where we just came from. So it's all still kind of there. It's just explained in a little bit different area, a little bit kind of better, I feel, and along with kind of how all of those options are broken down. Okay. Again, when we talked briefly on the offer to purchase about the knowledge that the escrow agent isn't always the firm, that it is a lot of times an attorney nowadays, this is just saying it's disclosing to your seller if you do or do not have a trust account, and if you don't, that whoever the escrow agent might be will be named in the contract, and that's how they'll know where that money is going to be. Okay. And then they took a lot of these little things out that I've always thought were a little silly. Seller represents that the seller has owned the property. Well, have they or haven't they? They're not just representing that they know, they know if they've owned the property for a year or for less than a year and don't own it yet. Same thing on access. They represent that they have legal access to a public right of way. They know if they do or not. So yes or no, not that we represent. The residential property disclosure still has the representations and all of that, but these things that are in the listing agreement, the bar association, everybody just does acknowledge that it's yes or no. It's not that we represent it, it's yes or no. Okay. And they've changed this, which is, it's nice. So because you don't, if you have a homeowners association, that doesn't, you need the residential property disclosure for houses that don't also have a homeowners association. So this has just kind of been changed around a little bit, saying yes, no, whatever. So like I said, it just never really made sense before. So now all of that's kind of been wiped away. Is there an owners association or no? Okay. Same thing, to the best of seller's knowledge, is it or is it not in a flood zone? Does it or does it not have synthetic stucco? Does it or does it not have a termite bond? Do they or do they not have a mortgage? Okay. Same thing on a lease, FHA appraisal. The item starts coming back on a few things. Like I said, with the buyer having to come up out of due diligence, knowing whether there's special assessments or not. This has changed to, there are assessments that have been approved or are under consideration. Okay, so that's already a little bit different than what the offer to purchase says. So this is the first chance for the seller to say that they've definitely been approved. Hopefully they would know that, or that they're under consideration. So if they know that the owners association or some sort of governmental entity has disclosed to them that there should be this assessment coming up, this is their first chance to throw it out there. Because it's in the listing agreement, it is also your first opportunity to be able to gather that information and get it into the MLS. There is a section in Flex that does talk about assessments. If you know that these are there and it is now the buyers, it's part of their due diligence to figure this out. If we know these things, they become material facts, and go ahead and put that in Flex. You know, like if you know that this assessment is coming, put it in there, make everybody's lives a little bit easier and everything. We do have those boxes in there. Okay. Fuel tanks, again, they should know whether there is a fuel tank or not. So coming back to how the listing agreement used to look and what it's looking like now. Yes, we are now saying that it is part of the buyer's due diligence to know whether these assessments are coming up, but it is now under the seller's duties to disclose what they know. Okay, so before, under seller's duties, if you look at a listing agreement from this year, from 2020, this last section right here that's highlighted doesn't exist. Okay, you have these items all exist under seller's duties. This one does not. It does, because we're not trying to say that the seller has no responsibility to tell their agent and the firm, and therein disclose to the buyers what they know. We're just saying that if it's an assessment that comes up after closing, that is part of the buyer's due diligence. Okay, so this goes from reading, so seller agrees to cooperate with the firm in the marketing and sale of the property, including but not limited to providing the firm in a timely manner accurate information, including but not limited to the following. So we've always had the residential property disclosure, mineral oil and gas, lead-based paint disclosure if it's there, covenants, bylaws, articles of incorporation, rules, regulations, and any governing documents of the homeowners association. All of that was on the listing agreement before, but now it goes further than that to say that it is the seller's duty to provide to the firm accurate information on owners association statement of account, master insurance policies, current financial statements and budget of the owners association, parking restrictions, information, and architectural guidelines. Okay, so again, we're putting this into the buyer's due diligence wheelhouse, but it's not exempting the sellers from being responsible for passing along the information that they know. Okay, so this is a conversation to have with your sellers when you're listing their houses. Make sure you ask them for all the information that they have from the owners association. Okay, and then the title insurance, all of that was on the original listing agreement from this year. Okay, So the big one, the only other change here is that, you know, you really sufficient cause. It's a little bit of a, not a catch-all, but if it's legally sufficient, you should be able to terminate. You should be able to terminate, or the seller should be able to terminate. So just know that there's not just A and B for why you can terminate. If it's legally sufficient, you can terminate. So most of the other changes kind of come down to the terminations. They've changed the names of the terminations to make them a little bit more obvious which one you should be using, because it is confusing. There's a lot of terminations and they have such long names, and when you're trying to hover over them in whatever form system you use, sometimes it's kind of difficult to decide what you're supposed to use. But let's see, let's go to the basic changes are that you are making it very obvious that these are all unilateral rights to terminate. We all know that contracts have to be bilateral. If one party does not agree to continue being a party to the contract doesn't, you can't have a unilateral contract. So all of this is just kind of putting back on there which one you should use. So what NCAR and everybody suggests is that you're using the 350, 351, 352, 353, one of those forms that is a unilateral termination. There are going to be circumstances where both parties say, yep, we're done, and this is exactly what we agreed to, and you already know all of that. If you do, fantastic. That's form 390. Most of the time, though, you don't have all of that out ahead of time. So in those cases, if you have not absolutely agreed to every dispersal of everything and absolutely everything, go ahead and use the unilateral right to terminate, because then you're terminated. It does make it clear on these that right here, sellers. So this is the buyer saying that they are terminating. Okay, it'll say why. Is it during their due diligence period? Remember that if they want to use this, they would have had to have paid their agreed upon due diligence money, or that doesn't exist anymore. All of these things, but any reason why the buyer is unilaterally, they're just saying, I'm terminating. Don't care if the seller agrees or not, I'm terminating. And this is why they have made this note very clear. Seller's failure to sign this release does not affect the validity of the buyer's termination. So both sides do not ever have to sign a termination. So, you know, it's nice if both of them do, and it's nice if everybody agrees where the money is supposed to go on a nice piece of paper that we can provide rather than it going through the magistrate. But it's not necessary to terminate. To terminate, one side has to unilaterally put in writing, I'm out. Okay. So just because the seller doesn't sign this anywhere and release this earnest money doesn't mean that the contract isn't terminated. Okay, they may not agree where the money goes, but the contract is terminated. Okay, so that's the big thing on the terminations, but they changed all the names of them. So just you can kind of look through those, but you've got the buyer is exercising unilateral right to terminate. Buyer is exercising on vacant land. Buyer is exercising on I'm sorry, gosh, no, I'm just blind today. So seller is exercising, so it can go the other way. Seller is exercising on vacant land. This is the one, like I said, if absolutely everybody agrees to, then you can do the mutual agreement with release or without release, but you would have to know which one everybody is agreeing to. If you're going to use this one, you need to know who's retaining that earnest money or who's getting it back. Okay. And then all of the, a lot of these, like I said, just real kind of basic things, the agency agreement to renew and everything. They've just changed some of these little, it's just wording changes for the most part. The one that I did, fire agreement, no huge changes. It's just kind of what we've already talked about. Sorry. Confirmation of compensation. They basically just changed the name to disclosure of compensation, just so we know that this is disclosing to a client, not to the other broker. Professional services disclosure, they have added lines and just made all the boxes a little bit bigger. If you've ever tried to drag and drop signatures and initials on every one of the tiny lines on the professional services disclosure, you know that it overlaps quite a bit. So they have made it, expanded it a little bit, and then they've also added a lot more lines in the hopes that this can maybe take the place. I know a lot of firms have their own kind of inspection acknowledgements and all of that kind of stuff. But if you wanted to use the professional services disclosure, but your firm needs you to disclose certain inspections that aren't on here, chimney, I don't know, whatever, that you could actually, write those in there yourself and use this form. Okay. So, all right. So there's a lot. I do encourage everybody to, click on that link that Sharon sent out. If we need to send it back out by email or whatever, just let us know. But definitely, it's just a really cool form. Because like I said, you have all the explanations. So everything we went over, all of the explanations are in here. But if you click on these blue hyperlinks, they will take you to the mocked up forms. So you can see all those highlighted sections and really go through them. But you can read through all of why they made every one of these changes. And it's just absolutely fantastic. It really helps you get a sense of where they're going with this. Sometimes I know it seems like our contracts sway one way or the other. Before we had due diligence contracts, really seemed like kind of the ball was in the seller's court. And then we had these due diligence contracts, and now all of a sudden it's in the buyer's court. Like they can terminate for any or no reason. This is crazy, and the pendulum kind of swings back and forth when, things are noted that, especially if people are trying to game the system, everybody's trying to make these the most fair and equitable distribution of rights. And, at the end of the day, we want to put buyers in those sellers' houses, and we want everybody to be protected, including ourselves. And so these contracts are constantly being reworked to make sure that that's accurate, that it's fair, that fair housing is followed, that all of these things are followed. So when you do come across problems with the contracts or whatever, reach out. If you don't know who to reach out to Heather and Jamie at the board office and say, we're really having an issue with this. Who do we talk to about forms and all of this? All the local associations have forms committees and all of this. Regional has forms, committees that talk about how these things are supposed to work in theory and how they changes to North Carolina, or to come up with local forms. Most of you, if you work in the Jacksonville area, that we've got the WDIR form. That went through some pretty significant changes a couple years ago and everything. People outside of Jacksonville may not know what that form is, may not use it, but it was important to us. So we had a form made, and that those all can happen when it's, when it's important, when a need is seen. We want to do that. So, but yeah. Did anybody have any specific questions? Do you have any, anything you just want to talk about? Like, oh my gosh, why the heck did they do this to us? And why are they making our lives miserable? Because those aren't reasons for any of this, but we'd love to hear from any of you. If you want to stay on for a while, that's fine. If you need to go, I know we took an hour and a half on this already. That's it for anything I actually wanted to say. But feel free to stay on. Feel free to share the link, add your own stuff to it. Have team meetings about this. Talk about these things, because the better we can all work together, the better this will all go for everybody. But I really do truly believe that NCAR is looking out for us, and most importantly for our lovely buyers and sellers in this really difficult market. And there's some good changes here. There's some good changes, and we'll all get used to them. I don't think there's anything that's just so overreaching that we're going to really struggle with it. But we're always here. If you ever need my information for anything, if you just have questions about anything that I said or anything else, I am always happy to talk to anybody. If you can't search my name on Flex for some reason, you can always contact the board. That is my cell phone number that's in Flex. And I'm always really, like I said, we've got so many wonderful brokers in charge in our association. And I will say, I do sit on the board of managers for regional. Jacksonville is extraordinary from the top down. Our association leadership, Heather and Jamie at the board, are some of the best association personnel that anybody could hope for. And when you see kind of what other people have, you see that. But the educational opportunities that we have here, the classes, the brokers who are involved in getting their people the right information. I don't know too many other boards who are putting out forms changes. I know there's individual firms that do and everything, but Jacksonville does a really good job. You guys are in a good place to get all the information that you need and want, and there are actual people there to answer your questions. So if you ever need anything, please reach out to your board and everybody else. But if you ever have any questions, we are all very, very happy to help you. But I will stop talking for like 2 seconds if anybody actually does have any questions that they want to pop up with. But otherwise, thank you all so much for sitting through this and learning and really being master of your businesses. It's very important.